Next case is Joshua James versus State. No problem.
Have you ever done 3 in a row?
I have not. Closest I did was an argument here and then a federal sentencing in the afternoon. Hey, please the court. My name is William Pinnell, and I represent Joshua James, the appellant in this case. Please reserve 4 minutes of my time for rebuttal. As noted in our briefs, Mr. James is entitled to a new trial for 3 reasons. First, the trial court erred by permitting the prosecutor to make statements during voir dire indicating that Mr. James was charged in this case because the state had already determined that he was guilty. Second, the trial court abused its discretion by permitting the state to introduce evidence that suggested that Mr. James was on probation and was involved in the possession and sale of illegal drugs. And third, the trial court committed fundamental error because the jury instructions in the state's closing argument permitted the jury to convict Mr. James of first-degree felony murder based on alleged abuse that occurred on a date prior to the date in count 1 of the indictment. It's important to remember in this case that the jury specifically acquitted him of premeditated murder and found him guilty only of first-degree felony murder. It's our position that individually or cumulatively, these errors deprive Mr. James of a fair trial and that his conviction should be reversed. The first issue, during voir dire, the prosecutor improperly responded to a question from a potential juror and about how the juror should deal with a law the juror disagrees with. And the prosecutor, instead of just answering the question and saying, the legislator makes the laws, and can you apply the law, or can you fairly address a case in a case where you don't agree with the law, the prosecutor started talking about his personal opinion. It says that he doesn't agree with all the laws, but at the end of the day, he looks through the paperwork, and if it looks like I can prove the case beyond a reasonable doubt, I'm going to file it. The clear implication from that statement is that the state had already made a decision to charge Mr. James because they believed he was guilty. There's no reason for the prosecutor to discuss his personal feelings about laws or describe how he makes charging decisions. It's well established from this court's case decision in Brinson that the government cannot reference its charging decision or imply to the jury that it is predetermined that the defendant is guilty of the charged offenses. That's also the rule in the Johns case from the 2nd DCA 2002. In Brinson, the prosecutor made a similar statement in opening. My office reviews these complaint affidavits and whether they should file charges or not, and our office did decide to file charges. That's why we're here today. Very similar to the statement in this case. In the Johns case, during closing, the prosecutor argued the state had charged the right person and only brought charges it could prove, implying the state only charges those who are guilty. Again, similar to the statement in this case. So it's our opinion that the trial court erred by overruling that objection, and that constitutes reversible error. Now, I know the state argues that it wasn't preserved and it's a different argument. I disagree. The trial lawyer specifically approached the bench and said it's going towards his belief in the strength of the case. And that's at page 145. So the trial lawyer clearly indicated that the statement by the prosecutor was the prosecutor's personal opinion and improper, so it was preserved for review. It's the same argument on appeal. State also argues that it was not properly preserved because there was no objection prior to the jury panel being sworn. It's our position that that's also incorrect, that this should be treated like an improper closing argument or improper opening statement. It's not a jury selection issue where a particular juror should have been excused for cause or the jury wasn't sworn. It's an improper comment. So once there's an objection and it's overruled, it's preserved. We acknowledged a Lavin decision. We think that's incorrectly decided and factually distinguishable. Because in that case, the judge actually sustained the objection, so it made sense in that case for the defense counsel to ask for a remedy. Here, the objection was overruled. So it's our position that it was preserved, and we cite the Marston and Verona cases. In both those cases, during voir dire, the prosecutor made an improper comment on the defendant's right to remain silent. In both cases, the defendant's objection was overruled, and no motion for mistrial was made, and there's no indication in either of those opinions that the defendant objected to the jury being sworn. But despite that fact, the second DCA and the fourth DCA found that the issue was properly preserved. So we believe that the issue was preserved by an objection and the trial judge overruling the objection. If for some reason the court finds it wasn't preserved, we argue it's fundamental error pursuant to Brinson, where they found fundamental error under similar circumstances. Also because this is at the very beginning of the case, and you're allowing the jury, before any evidence is presented, you're telling the jury that the state's made this predetermination, and we only filed it because we knew he was guilty. It's not harmless. This is a circumstantial evidence case. It's a close case. No eyewitnesses to Mr. James abusing the victim. No statements from him admitting to any abuse. He provided a consistent story to the police, and he actually brought the victim to the hospital. So this isn't a slam dunk case for the state. It's a circumstantial case. There was a close call, and this improper statement of the prosecutor may have tipped the scales in favor of the state. Secondly, the trial court abused its discretion by permitting the state to introduce evidence that suggested that Mr. James was on probation and was involved in the possession and sale of illegal drugs. The evidence was irrelevant to the charged offenses and prejudiced Mr. James by advising the jury that he was involved in uncharged criminal conduct and had a prior criminal record. The facts of the case are that the trial court originally granted the motion in limine to preclude admission of this evidence and subsequently changed its mind during the trial and found it was relevant only to charge number 3.
Was the reason why the defendant did not take the child or did not call 911 and have the child taken by ambulance relevant to count 3?
I don't think so, Your Honor. I think the sole issue, was it negligence? Was it culpable negligence or an unlawful failure to provide necessary care to not call 911? I don't think his motive is relevant. I think is that negligent? I don't think it matters why he did it. This isn't a murder case where you're trying to prove a state of mind of...
Doesn't it counter his explanation of why he did it, didn't call 911? Doesn't the state have the right to introduce evidence from which the jury might infer that he was lying about his stated reasons for not calling 911?
Generally, Your Honor, but again, I think this is a unique case where the motive isn't relevant, and even if it had some marginal relevance, I think the state went overboard and the trial court went overboard by allowing both evidence that he was on probation and evidence that there was the odor of cannabis.
I mean, the probation is relevant. If the first premise that I stated is correct, that they have the right to introduce contrary evidence to the explanation that he offered to the police, his motive is simple. He had drugs or drug paraphernalia in the house, and he was on probation, so if he got caught with the drug paraphernalia, he would suffer severe consequences for having violated his probation. I mean, all of that seems to me to be something that the jury gets to consider in the context of his articulated purpose for not calling emergency services.
I disagree with the court that motive is relevant in this case. I don't.
You're only disagreeing with me because I'm the one that said it, not the
Okay,
court.
okay.
So.
The question is whether his conduct was negligent or improper. His motive isn't relevant. It's not like a first-degree.
How did his testimony as to what his motive was come into evidence?
State didn't object to it.
I'm sorry?
I came in, I assume, through the introduction of his interview.
All right, and was there an objection at that time to his motivation coming in? All
I believe that was introduced in the state's case. That's.
right, and you didn't, defense didn't object, saying it's irrelevant what the motive is, so that comes in, right?
Not that I'm aware of.
I'm sorry?
Not that I'm aware of. I don't know the answer to that.
So if it was relevant, his position as to what the motive was, why isn't it relevant testimony that can discredit that testimony that went in without objection?
I don't think the defense has an obligation to object to testimony, in the state's case, and then loses the right to object to irrelevant testimony in the later. So, but assuming
Well,
that.
I'm sorry, let me back up just a
Sure.
second. Didn't defense counsel argue that in his opening statement?
Argue what?
That the child was not insured and the mother and appellant were concerned about costs? And that's why the ambulance wasn't called? I mean, was that argued by defense counsel in opening
I believe so. I believe so. But again, we're talking about high, dangerous testimony, dangerous evidence. We're talking about presumptively prejudicial testimony about collateral crime conduct. So there's a 403 balancing test here. I think evidence of motive in this case, if relevant, it has very marginal relevance. It's certainly, everybody agreed it was only relevant to count 3. So the least serious charge of the 3, maybe it's relevant to that. It's borderline. Even the judge struggled with that.
Well, let me ask you about the motive. If you had a badly malnourished child, could the defense raise, we didn't have money for food? Versus the state then saying they had plenty of money for food. All the other kids ate well, but they wouldn't feed, but this kid never got food. I mean, would that be relevant on a child neglect case if child wasn't fed because there was a lack of money to buy food versus a child wasn't fed because they were punishing the child?
I don't think that the lack of money for food would be a legal defense to not providing your child with food. So I don't think the motive matters in that case. I think the question before the court was what he did improper or negligent, not why he did it. It's not like a first-degree murder case where we're talking about premeditation. And again, if there's some relevance to it, it's certainly outweighed by presumptively prejudicial testimony that the Freeman court even said a curative instruction cannot cure. So we believe that, and then this court's decision in Crosby from earlier this year said that you can introduce too much collateral crime evidence. And I think that occurred here. There was no reason to introduce both the drug evidence and the probation. It became a feature of the case, and again, it's a closed case, only relevant to the least serious crime, maybe.
Isn't the mere possession of, I think it was marijuana they smelled, right, cannabis, or cannabis paraphernalia, isn't that a fairly insignificant crime? But when it's done by a probationer, doesn't that explain, why he'd be afraid to have police and ambulance traipsing around in his residence?
Again, under the 403 balancing, I think it's overly prejudicial, and now you're having, instead of the question being was he negligent, now we're having evidence that he's a drug dealer. There's a scale. There's an odor of cannabis. He's on probation. It's too much, and it changes the central issue in the case. I'd reserve the rest of my time for rebuttal.
Got about a minute and a half left.
May it please the court, good morning, Kelly Nealon on behalf of the state of Florida. Issue 1 was waived. He didn't just not object to the jury. The defendant personally accepted the jury, and defense counsel personally accepted the jury. As to the drug evidence, this wasn't just culpable negligence, it's whether he willfully or by culpable negligence failed to render care to the child. So it was relevant to that issue, as I've explained in my brief, and if the court doesn't have any questions, I'll rely on the brief.
Thank you, counsel.
Thank you.
Any rebuttal?
I'll just rely on my previous argument, my briefs. Again, I think that the 403 analysis is important, and I think that the issue was preserved, so I'd ask the court to reverse.
Thank you, counsel.